I would argue that if you got 4 people surrounding you and you getting stomped out, you on the ground getting battered and bruised, and you feel like your life is in danger, and you come up with a blade and you put one of them out of their misery, I would say.
Willie D Live.
It happened on April 2nd, 2025 at a high school track meet in Frisco, Texas. Okay. They went to 2 different schools. One of them went to Memorial High. The other one went to Centennial High. They were there. It was about 10 o'clock in the morning. There were other children around. This wasn't some random kid walking into some other school space. Another person had invited him in. Karmelo was sitting there minding his business, right? We can all agree he was minding his business, talking to his friend, and who had invited him in. It was a rainstorm, so you had a lot of kids who were seeking shelter. And then, but he wasn't quiet. Okay. Apparently he said the following. He said, in reference to their football team, and I'm talking about Austin Metcalf's football team, he said, y'all are ass. Y'all team is ass. And I get it, a little back and forth banter. But I can see how Austin Metcalf would have taken that offensive. Playing high school football myself, I know how I feel. This is our tent. You over here talking stuff about us. Okay, got it. But it's a joke. I think his friend said it was a joke. He understood it was a joke. And this is the same friend who said, I don't know who Karmelo Anthony is, until the defense lawyer showed him a bunch of photographs that they've been hanging out together. Okay.
That's the Eddie guy, right?
Yeah. Now, here's the thing. The prosecution put up 9 witnesses. They have varying stories. We do have Austin and his brother Hunter and Metcalf in the same general area. There's a question as to whether he was standing next to him or he was at the back of the tent. Now, here's the thing. This is not for most people who aren't Texans. They might not understand what's going on, but I've sat up in those stands where there's 100 degrees outside in the summertime, or whether it's raining outside. You will have people who will bring their tents and set them up in the stands, the same stands that you watch a football game. Oftentimes you'll put a tent there. It could be varying size, and people will come sit under there. I get that. I've been there before. I got my own kids. My own youngest son plays football. But the bottom line is, Karmelo was confronted. He said, "Who are you?" He said, "I'm a nobody." This is what the witness is saying. Some words were exchanged. It's an issue as to whether or not it happened instantaneously, or whether or not the situation went back for 3 or 4 minutes. What we do know is that at some point, Austin Metcalf, he put hands on the boy. Okay, when I say the boy, he touched Karmelo. Karmelo never moved. He never moved. He sat in the same seat. He never moved. He put hands on him. He was standing over him. This is what the witness is saying, not me. All right. And then he pushed Karmelo. And now here's the thing. Some of the witnesses saying this wasn't just a push. This was a linebacker push or a lineman push where you really dig into somebody, go into him and push him up. Okay. So this is the type of force that we're talking about. A football.
And remember, you're in the stands.
You're in the stands. I get it. You're in the stands, so you could get tipped over. You can fall down. Any of that could happen. Okay. But we also, since we are in the stands, brother, we're not in an alley in Brooklyn at 2 a.m. Okay. We're not in South Central LA and you got, you in the alley somewhere and a bunch of people from the other side rolled up on you. We in a bleachers in a football stadium at a high school. Okay. So and it's raining and there's plenty of witnesses around. So a lot going on. It's 10 o'clock in the morning. But bottom line is he put hands on him first. We can all agree with that. Now, the question is not whether or not he initiated the contact. He was sitting there the whole time. He didn't initiate the contact. The question now is, was his use of force reasonable in response? Because self-defense does not give you the right or give you a license to kill. First of all, let's establish this. Number one, he had the right to be under the tent. However, according to the Frisco school board or Frisco public school, you're not supposed to have a knife on campus. That's part of the students aren't supposed to have knives. And why? We don't want 17-year-olds walking around with deadly weapons because we know kids are not fully mature and they do crazy things. This is why we ban, folk from drinking. We ban people from having gun licenses until a certain age. We do that. Okay. But the bottom line is let's go over some of the actual penal codes here. And I want to start with, let me say it like this. In Texas, you got murder, you got capital murder, you got manslaughter, and then of course you got self-defense question. The issue isn't just whether Karmelo caused Austin Metcalf's death. He said he did. Okay, when Alvarez, the police officer, came in and arrested him, he said, I did it. All right, but that doesn't admit that he murdered. That's an admission to the act. It's not necessarily an admission to the legal crime. The legal question is whether that act was murder, manslaughter, or justified self-defense. Now, I'm going to throw some numbers out here. We're going to talk about Texas Penal Code section 19.02. All right. A person commits murder if he intentionally or knowingly causes the death of another person. A person also commits murder if he intends to cause serious bodily injury and commits an act clearly dangerous to human life that causes death. So if you pull a knife, use it during a confrontation and somebody dies, the state is going to argue that fits under the definition of murder. Even if the state can't prove it specifically that you intended to kill Willie D, they can argue he intended to cause serious bodily injury and committed an act clearly dangerous to human life. Now let's talk about capital murder, because a lot of people think, it's not just, everything is not capital murder. Typically, there has to be a murder to take place plus an aggravating factor. In other words, you robbing somebody and you murdered them, okay? Or you kidnap somebody, or it's a murder for hire, or you murder multiple victims. That's capital murder. That's not what we're dealing with right here. That's off the board. Now you got manslaughter. People a lot of bring this up. This is 1904. Now, manslaughter is when a person recklessly causes the death of another person, and that's a lesser path. That's where somebody says, we didn't mean to kill him. He acted recklessly. He pulled a knife. That was stupid. It was emotional. It was a dangerous moment, and the kid died. That's possible. But if the jury believes he intentionally or knowingly used the knife in a way clearly dangerous to human life, then they can still say murder. Now let's talk about self-defense, because this is where it gets, this is the meat of it. All right. Karmelo didn't take the stand to testify. Everybody knows that he didn't stand. Now you don't have to take the stand. You're innocent until proven guilty. Okay. And you can raise the self-defense without the defendant taking the stand. Karmelo didn't have to testify personally to get the self-defense arguments before the jury. His lawyers can raise it. They can use the evidence. They can use witness testimony. They can talk about the physical evidence. They can mention the fact that Austin was 6'1", 210 pounds, and Karmelo was 5'8", 140, 150 pounds. He wasn't a bigger kid. They will say that he was sitting down. They will say that the other boy was standing up, and who touched who first. They'll say all that. Okay, but what Karmelo said, and they'll even bring up what Karmelo said after the incident. Hey, he touched me first. Those things come in. But see, here's the problem. Raising self-defense isn't the same as winning self-defense. And see, this is where Karmelo has a problem. Let's look at another code. Texas Penal Code section 931 covers ordinary self-defense. Ordinary. In other words, a person can use force when he reasonably believes force is immediately necessary to protect himself against another person's unlawful force.
But didn't they say that Karmelo got jumped? If it's more than just Austin jumping him, he got 5 kids on him. I can reasonably say that I'm in fear for my life.
That was something that I heard pre-trial. But that's not what them 21 witnesses came up there and said.
Those 21 witnesses were all memorial students and staff members, right?
And the 4 witnesses that testified for the defendant didn't come up and say that. Now that's what we heard preliminarily, but that's not what's before the jury. Now, if you want to change the scenario, I would argue that if you got 4 people surrounding you and you getting stomped out, you on the ground getting battered and bruised, and you feel like your life is in danger, and you come up with a blade and you put one of them out of their misery, I would say that's necessary. But see, that's not ordinary self-defense. And see, I'm gonna get to that in a minute. See, let me get here. A person can use force when he reasonably believes force is immediately necessary to protect himself against another person's unlawful force. So if Austin pushed, grabbed him, or tried to move him, which is what the evidence showed, Karmelo had the right to push back. He had a right to still off on Austin. He had the right to drop them 5th Ward Bs on him. You understand what I'm saying? He had a right to do that. Okay. He had a right to swing on Austin's jaw with the haymaker from the promised land. He had a right to do that. But see, but that's different than using deadly force. That's different. That's very different. See, Texas Penal Code section 9.32. And I don't want to. We're not doing a law school class, but I gotta lay this foundation because I know a lot of people are gonna watch this, and I want to give them the reference. There's a difference between ordinary force in response as opposed to deadly force. When is deadly force justified? If the person would be justified in using force, you look at that statutes, Texas Penal Code section 9.32 and 9.31. When a person reasonably believes, and that's a very important statement, reasonably believes that deadly force is immediately necessary to protect himself against another person's use or attempt to use unlawful deadly force or to prevent certain serious crimes like aggravated kidnapping or murder or sexual assault or aggravated assault or robbery or something like that. You have a right to use deadly force. And for you all who don't like that, and I know it's some people who gonna be mad at me. All right. Where's the deadly force coming from Austin's side? I get the fact that he pushed him, Willie D. I get the fact that I get the fact that he might have jacked him up like a linebacker, but where's the weapon? Where's the knife? Where's the gun? Where's the baseball bat? Huh? Where's the evidence that he was about to suffer serious bodily harm from being shoved? Now you mentioned that, we were on the incline.
Yes, yeah. I
get that. Okay. I get that. I get what you said, and it could have happened. All right, it could have happened, right? But again, I don't see a knife. I don't see a bat. There's no evidence that the boy was being jumped. And see, Texas. Go ahead, brother.
Normally, Dennis, what a lot of people like to say is, look how big he was. Look how much bigger he was than me. That right there, he could have killed me because he's so big. We've seen many cases like this where guys who tower over other guys end up dead. The little guy killed him, and they say, well, I can see I would be scared. I would be in fear for my life also.
All right, so now we talk about reasonableness. And so now we got 2 17-year-old boys here. One of them is about 6'1", the other one is about 5'8", 5'9". I done seen many a 5'8" dude put hands on a 6 foot plus dude and lay him out. I'll set up. I'm over at Reverend Ray Martin's gym all through the 2000s watching dudes get their hat handed to them, messing with the wrong one. I'm talking about somebody 5'4", okay, putting hands on somebody 6'2". Go ahead. I know you a boxer yourself. You know what I'm saying?
We know that happens, right? Mm-hmm. When you go into a courtroom, the argument is always, look how much bigger than he was. And the assumption is the bigger guy has the advantage.
The assumption is the bigger guy has the advantage. I get that. But again, just because he had the advantage, he didn't hit him. He pushed him. And in response, the boy came up with the blade and stuck him. And he bled out. Okay. So the question is, Okay, and again, I want to go back to what the Texas law defines serious bodily injury as an injury that creates a substantial risk of death, causes serious permanent injury or disfigurement. Did that push rise to the level of something that you would a reasonable person would believe would cause the death or cause some sort of long-term impairment to a body part or a body organ? So again, the question is whether Karmelo, it's not whether or not he was embarrassed. It's not whether or not he was uncomfortable. It's not whether or not he was angry. It's not whether or not even that Austin put his hands on him. The question is whether Karmelo reasonably believed deadly force was immediately necessary. And I don't see that.
Well, let me ask you, what if like the police, and I know police got qualified immunity, but what if like the police, he genuinely, reasonably feared for his life because this big guy is towering over him and he got back up and all these guys are around him. You know, he's surrounded by these guys. What if, is that an argument that the defense could have made?
I mean, that's an argument that he could have made, but he would have had to take the stance to put everybody in the mindset that he was in at the time, and he didn't take the stance. And see, it's a double-edged sword. You put this 17, I think he's 19 now. You put this 19-year-old boy on the stand, you subject him to cross-examination, and he goes off the rails and says some things that make the jury like him even less than they like him now. You see?
But they don't like him now at all, right?
Yeah. Well, I mean, you know,
hate him more than they hate him now.
Yeah, and again, we're not talking about a grown man who's had some life experience. We talk about a 17-year-old boy, whose brain is not fully developed, right? Which is why we don't give kids knives in the first place. But the bottom line is, man, this situation happened in suburban Frisco, Texas, wide open daylight, football stadium, kids and coaches around. Okay, and you got two 17-year-old boys from a rival school. So my thing is this. He might have been surrounded by some of Austin's football friends, but there were other people around. We can't assume, again, this is not a dark alley in Compton, California somewhere where nobody else is around. All right? Again, Austin was wrong. He shouldn't have put hands on the boy first. Okay? He shouldn't have tried to push him. He shouldn't have tried to force Karmelo out the tent. All right? But see, under Texas law, that doesn't justify using deadly force in response. You can push back, you can swing on them, okay? But you can't pull a blade out and stab a person and use deadly force. And see, the jury, even if they wanted to rule in favor of acquittal, they're going to have a hard time getting over that. See, Texas, go ahead.
Finish.
I was going to say Texas does have. There is this language, they call it the no duty to retreat language. Okay, we've heard that. Some people call it stand your ground. If a person has the right to be where he is, and he did, right? He hasn't provoked the person against him. He isn't engaged in any criminal activity. Then the law says he's not required to retreat before using force or deadly force. But no duty to retreat doesn't mean you have a free license to kill. You still have to meet the deadly force standard. You still have to reasonably believe deadly force is immediately necessary. And that's why Karmelo not testifying matters. Karmelo didn't have to take the stand. I said that before. Now, I understand why a defense lawyer wouldn't want to put their client up to testify in a murder trial, but without this testimony and without clear video footage showing exactly what happened, because they don't have that, then the jury they don't get to hear directly from him why he believed he was about to suffer death or serious bodily injury. They've got to accept these alleged statements. And I don't think it rises to that level. I don't think that. It doesn't justify that. They still want to know, well, why'd you have the knife in the first place? If the Frisco school district policy is that you're not supposed to have a knife or anything that looks like a weapon on campus, and you have it with you, how do you? What is the jury doing? He's not supposed to have the knife in the first place, and so now you use the knife for deadly force. Now, again, some people may say, well, it was because initially I heard it was a cleat knife. Initially, I heard, where it's a track meet, sometimes kids use cleat knives. He might have just got this knife that he had to you sharpen his cleats, but he's not supposed to have it in the first place. So you got to get around that. All right. And again,
what do you think was the most powerful piece of evidence that the prosecution presented?
The admission that he did it.